Hello and welcome to Daily Prelims Practice, where we take up the questions from the Hindu and the Indian Express and curate the question as per the demands of civil services prelims. The topics for the discussion have been listed on your screen.
Moving on to the first article of the day that has featured on page 17 of the Indian Express, basically talks about the NCLAT and about the issue of Z merger with the Sony Group. Now, UPSC under the economic section has asked continuously about the initiatives that have been introduced by the government, and the IBC India was introduced by the government to ensure faster resolution under the bankruptcy law. Now, a practice question in this regard can be framed on the insolvency and the bankruptcy code, as UPSC in 2019 has also asked a question related to the intercreditor agreement under the economic section, and such a question regarding the IBC can very well be expected in the coming prelim examination. The practice question here says, consider the following statement with reference to the IBC code of 2016. The first statement here is the National Company Law Tribunal is the deciding authority for corporations and the partnership firms. Now, this statement is incorrect. The IBC Code of 2016 provides for NCLT as the deciding authority for corporations and limited liability firms. Individuals and partnership firms have their debts that have been adjudicated by the Debt Recovery Tribunal. Moving on to the second statement, it says the pre-PRAC insolvency resolution process was introduced for all corporate agencies in financial distress. Now, this statement is again incorrect. The pre-packed insolvency resolution was introduced for MSMEs, for which a separate amendment was made, and the amount required to initiate a pre-packed insolvency resolution is between 10 lakh to 1 crore. So, pre-packed insolvency resolution process was introduced through an amendment and was primarily for the MSMEs and not for all the corporate agencies. Moving on with the question further says which of the statement given above is or are correct, and as none of the statement given above is correct, the correct code for the given question will be option D. Further, the correct code for the previous year question is also option D. Moving on to the next article of the day that has featured on page 15 of the Indian Express, basically talks about the Ukraine war, which has now completed 1 year. Now, this article under the explain section points out about the condition of Europe after 1 year of the Russian Ukraine war and also highlights the stand that India has taken in this regard at the level of UN and at different organizations. Now, UPSC in the previous examination has asked questions related to various places that were in news at that point of time. And such a question was seen in the year 2018, where UPSC asked about the regions that were in news. So, the locations related to the Ukraine region also becomes important from the perspective of prelims examination. The practice question here says consider the following region. The first region here is Trespol, second is Kherson, third is Senkivka, and the fourth is Korensk. Now the question further asks which of the following or above location falls in Ukraine. Now, if we look at the map that has been given in the newspaper, Trespol falls in the country of Moldova. Korensk, on the other hand, falls in the Russia. Kherson is a part of Ukraine and was under heavy bombardment from the Russian side. And Senkivka is the border area between Ukraine and Belarus, wherein the Belarus allowed the Russian forces to enter into Ukraine through this side. So Kherson and Senkivka are only the part of Ukraine, and Trespol and Kornsk are not the part of Ukraine. The question further says which of the following statements given above are correct, and as only 2 and 3, that is Kherson and Senkivka, are the part of Ukrainian territory, option B here is correct. Further, the correct answer for the previous year question is option C. Moving on to the next article of the day that has featured on page 1 of the Hindu, basically talks about the revenues under the GST, that is the goods and service tax, and has recently recorded the second highest monthly collection. Now, UPSC under the economic section has asked questions related to various taxation measures that have been adopted by India, and such a question related to GST only was asked in the year 2017, wherein the question was framed that what are the advantages of implementing GST. A question in this regard on the very basic nature of GST can very well be asked in the prelims examination, and the practice question here says What is and are the salient features of goods and service tax? The first statement here is it is based on the principle of origin based consumption taxation. Now, this statement is incorrect. GST is based on the destination based consumption taxation as against the earlier principle of the origin based consumption taxation. So, GST is based on destination based consumption taxation. GST further is applicable on supply of goods or services rather than the earlier applicable formula on the manufacturing of goods or services. Moving on to the second statement, it says tobacco and tobacco products would be subject to GST. Now, this statement is correct. The tobacco and the tobacco products are subjected to the GST, and in addition to that, the center also has the power to levy central excise duty on these products. Moving on to the third statement, it says GST would apply on all goods and services, including alcohol for human consumption. Now, this statement is incorrect, as GST would be applicable on all the goods and services except for alcohol for human consumption, and also GST on five specified petroleum products, that is the crude, petrol, diesel, natural gas, and the aviation turbine fuel, are kept out of the purview of GST, and the GST would be applicable from a date as it would be recommended by the GST Council. Moving on with the question, it says select the correct answer using the code given below. And as only statement 2 here is correct, the correct code for the given question will be option B. Further, the correct code for the previous year question is option A. Moving on to the next article of the day that has appeared on page 15 of the Hindu, basically talks about the World Bank. Now, the US President Joe Biden has announced that he is nominating MasterCard former chief Ajay Banga to lead the World Bank. Now, multilateral institutions or the international institutions of importance have been a recurring theme in the UPSC Prelims examination, and a question specifically linked to the World Bank was asked in the year 2016, wherein UPSC asked about the Ease of Doing Business Index. And the practice question here says, consider the following statements regarding the World Bank. Now, the first statement here is the International Finance Corporation provides low or no interest loan to low income countries. Now, this statement is incorrect. Basically, the International Bank of Reconstruction and Development, that is IBRD, and the International Development Association, that is the IDA, form the World Bank and which provides technical, financial, and policy advice to the government. And under the World Bank, there are basically 5 developmental institutions that work for it. It is the IDA which provides for low or no interest loan to the low income countries, and IFC, that is the International Finance Corporation, on the other hand, provides investment advice and asset management to companies. So, first statement here is incorrect. Moving on to the second statement, it says India is not a member of MIGA, that is the Multilateral Guarantee Agency, and ICSID, that is the International Center for Settlement of Investment Disputes. Now, this statement is also incorrect. The Multilateral Investment Guarantee Agency ensures lenders and the investor against the political risk that may take place in any country, such as that of war, and India is member to this, wherein the International Center for Settlement of Investment Disputes settles disputes between the investors and the countries. But India has decided to not join this institution. So statement 2 here is also incorrect. Moving on to the third statement, it says India has established its own BRICS arbitration center to strengthen international arbitration with the foreign investor. Now, this statement is correct. India is not a member of ICSID, as we have already seen. India, on the other hand, has established its own BRICS arbitration center, but this mechanism, as to remember a point, is currently limited to the BRICS countries only and is to be assumed to further expand it to the emerging economies. So, statement 3 here is correct. The question further says which of the above statement is or are correct, and as only third statement is correct, the correct code for the given question will be option D. Further, the correct code for the previous year question is option C. Moving on to the last question of the day that has appeared on page 9 of the Hindu, basically talks about the anti-defection law which has been in use for some point of time, mainly because of the court case that was before the Supreme Court regarding the allocation of symbols in the Shiv Sena case. Now the article talks about the need for the change in the anti-defection law. Now, UPSC in the previous year, in the prelims examination, has asked questions related to various amendments and also about a question directly linked to the anti-defection law in 2014 as it was seen. A practice question in this regard can be framed. The practice question here says, with reference to anti-defection law, consider the following statements. The first statement here is, a member of a house belonging to any political party cannot be disqualified for being a member of the house if he voluntarily gives up his membership of such political party. Now this statement is incorrect. Now a member is disqualified if he voluntarily gives up his membership of such political party, that is case A, and in case B, he is also disqualified if he votes or abstains from the voting in such house contrary to any direction which is issued by his political party without obtaining the prior permission. And this is also the issue where it highlights the lack of internal democracy or the personal judgment of the member. So statement 1 here is incorrect. Moving on to the statement 2, it says the disqualification on the ground of defection does not apply in case when a member goes out of his party in case of split by one-third member of the legislature party. Now this statement is again incorrect. Now if a merger takes place, it has to be when two-thirds of the members of the party have agreed to such member. Now under the provisions of the 10th schedule pertaining to the exemption from disqualification in split by one-third member of the legislative party has been deleted by the 91st Constitutional Amendment Act of 2003. It means the defectors have no more protection on the grounds of split in the party. And only in the case of merger, that too with two-thirds of the members agreeing to the same process, is applicable. A question in the 2022 prelims examination was also framed on similar lines. The question further says, which of the statement given above is or are correct? And as none of the statement given above is correct, the correct code for the given question will be option D. Further, the correct code for the previous year question is also option D.